Welcome, I'm Russell Alexander. If you like this video, please share it with your friends and colleagues. Today we're going to talk about helping family businesses survive the pandemic and divorce. Family-run business owners fear how divorce will affect the business they have spent their life building. While business owners have control over the work they put into their business and the legacy they are building, for their family they may have little influence over the relationship breakdown. Breakdown on a business can cause additional stress and above and beyond the heartache associated with restructuring a family during a divorce. In many family law matters involving children, a family business can be used as an incentive, fueling conflict as almost unavoidable side effect of the court system. A collaborative approach is very effective in reducing the impact of separation and divorce on family-run businesses. This process seeks to ensure that businesses remain viable for both spouses, as well as future generations. What is collaborative practice? Well, the underlying philosophy of collaborative divorce or collaborative practice is that the parties mutually agreed to avoid the court process, with the result being a faster, sometimes cheaper, more amicable divorce or separation. COVID-19 and the pandemic have many court matters not being heard right now. They're only hearing emergencies. However, collaborative practice meetings are still functioning remotely on an ongoing basis. Recently, I settled a collaborative practice case in under 7 days. We have another video you can learn how we did that. Collaborative practice offers an alternative to going to court. The collaborative process allows spouses to shape the outcome of their separation and divorce. Judges in the court system, by contrast, have limited statutory options available when it comes to settling cases involving businesses. Outcomes in the family court are framed by legal rights and the obligations of the parties under the Family Law Act and the Divorce Act. The family court will not consider the time and effort that goes into building a business and running a business. It may not be well equipped to adjudicate issues of income when the revenue generated by the family business is not necessarily guaranteed or consistent. Issues such as liquidity of assets, risk associated with owning a business, ensuring that funding remains stable, are complex and often the fodder for experts, and oftentimes result in disputes hiring their own experts who duel it out in court and approach the issue in a very litigious manner. This legal endeavor usually ends up costing families several $100,000s in legal and court fees. The court may order a sale of the business at a significant discount. This may ultimately result in a significant loss of family wealth. The collaborative practice, on the other hand, is an option that operates outside of the court system. Rather than simply applying a legal model, our goal is to focus on goals and interests of the parties and create a flexible outcome. It opens the door to creative settlement options that would not otherwise be available in a court setting. It ensures privacy, tax planning, the orderly transfer of corporate shares. Flexible payment structures can be created to ensure that the business is not destroyed in the wake of one spouse leaving. It fosters health of the family business and promotes growth and stability for future income. It enables the building of capital which ultimately will support the family unit. Other options that can be considered in the collaborative approach include family trusts or holding companies as a method of sharing income from family business, tax planning to avoid the possibility of a Canada Revenue Agency audit, considering the new formation of family trusts, employment of the children in the family business, estate succession and capacity planning, ensuring the proper insurance is in place to cushion the effects of any risks, gifting shares or portions of the family business to the children or other family members, maintaining the privacy of the family-run business, and managing continuation of income streams, splitting income amongst family members, possibly delaying equalization or sharing business payments, such as if the family business sells at a later date, and preserving the family legacy for future generations. Recognizing and predicting the ebb and flow of market and business patterns, and the additional benefit of involving neutral professionals. These neutrals are able to address relevant areas of the family law matter, often with more experience in their particular field than the lawyers. Neutrals can take on some of the information gathering that would ordinarily be completed by the spouses, which can be stressful. Neutrals can, in an efficient way, deal with issues in a cost-effective manner. Family professionals and financial specialists may include accountants, financial planners, business evaluators, those who have expertise in helping separating families address issues relating to the family business. They play a vital role in the collaborative process by ensuring that clients provide full and frank financial disclosure. Financial disclosure includes aspects of such income and liability, assets of both the spouses and their debts, and the business. A business evaluator may assist in valuing the business and complete an income analysis to determine yearly income for support purposes. Financial specialists thoroughly vet the documents and prepare a detailed report for the lawyers and the collaborative team to streamline settlement discussions. Financial specialists further add value to the collaborative process, helping to manage the expectations from a neutral perspective. Another key benefit of a financial professional is their ability to even the playing field. A financial neutral can spend time separately with both parties to ensure that all the cards are on the table and that each spouse understands the basis upon which they are negotiating. Family professionals, on the other hand, with many of the underlying issues associated with restructuring a family and a family-run business. Emotions can run additionally high when dealing with the very real and salient issues associated with the individuals that make up a family business team. Interests may not be purely financial. And bringing these interests to the table, anger, loss, grief, is the role of a neutral in the part of the divorce or separation process. A family neutral gives family access to support and guidance for managing these emotions, which can intensify the conflict and derail settlement attempts in the traditional divorce. Privacy, protection, planning, these are another consideration that has arisen in light of the pandemic and its effect, and the importance of privacy and protection and planning in managing the effects of separation and divorce on family businesses. On our blog, we take a deep dive into these issues in a more extensive way. We offer case studies to show you how this approach can work and to help you keep the business out of the court system and help it survive. The collaborative process emphasizes privacy and planning. So we're offering a respectful alternative to the court system. Those for families who want to ensure their business legacy remains for generations to come. It could include estate planning, business planning. The business does not need to be destroyed by restructuring. Minimizing the financial and emotional impact of a separation and divorce on the family and their business allows spouses to take back control of your family's future from impartial third-party adjudicators. I hope you like this video. You can share it. If you have a question about this approach, please leave it in the comment box below. We're going to endeavor to answer everybody's questions at the end of each week. Thank you for watching our video today, and please be safe.